This is an appeal in the matter of the King on the application of Bibi and the Secretary of State to the Home Department.
Yes, Mr. Frazee.
Thank you. Good morning, my lords and my lady. I appear on behalf of the appellant in her appeal against the decision of Upper Tribunal Judge Kopicek, which dismissed her application for permission to apply for judicial review against the decision of the Secretary of State refusing her clearance as a visitor. My lords and my lady, there is a preliminary issue in this appeal.
Well, we know that Ms. Massoud is here representing the Secretary of State.
Yes, I agree. I have addressed that issue in the submission that I've handed over this morning in relation to the skeleton argument that I had filed.
Right, just give us a moment. There's something on our desk.
I'm grateful.
And it's a document dated the 27th of March, which is today.
Yes, my lord.
And is this something that Ms. Massoud has seen?
Yes.
When?
This morning, my lord.
Well, what does that mean? How long ago?
About half an hour ago, my lord.
Yes. Right. So we're not reading it yet. What's it about?
My lord, on the 25th of March, the Secretary of State's representative emailed to say that the replacement or the amended correctly skeleton argument that I drafted on the 6th of February 2025.
Shall we start with the last document that you say we have before this process? Which is the appellant's replacement skeleton argument. Replacement meaning that it's been upgraded since the grant of permission.
Yes. Yeah.
Which is in the name of yourself and Mr. Saidian.
Yes, my lord. That's right. Yes.
And that's dated when?
6th of February 2025.
Can I just check, Mr. Fansley, while we're on it, who your solicitors are, because the council slip says it's Chambers of Armoured Barrister.
That's
and your skeleton says it's Gulbenkian Nandonian.
That's right. My lady, I was assisted in this appeal by Mr. Saidian from Gulbenkian Nandonian solicitors, and those instructing me are aware of that. He helped with the authorities bundle as well as the core bundle, my lady.
So you're instructing
by the Chamber of Armoured Barristers.
Right. Thank you.
Yeah, I'm grateful.
Right. So now we have had and have of course read your replacement skeleton argument of the 6th of February.
Yeah.
So what is this document?
This, my lord, is an application to admit that document. It was served on the Secretary on the 7th of February, at the same time, on the same day in which it was served in the court. The Secretary took issue with that on the 25th of March, 2 days ago, my lord.
Sorry, two documents were served on the Secretary of State.
Just that document, my lord, yes.
Right, but I'm sorry I'm being slow.
No, at all, my lord.
The 6th of February,
yes,
your replacement skeleton argument was filed and no doubt served.
The next day, it was dated the 6th, my lord, but it was filed on the 7th of February, yes.
So the document that we've got
Yeah.
was what, sent at the same time?
No, my lord, this is sent this morning.
This is fresh, right?
Yes.
Okay.
So once it was pointed out.
Why are you, having filed a skeleton argument 6 weeks ago, why are you filing another one?
I'm not filing one another.
As I understand it, you filed your replacement skeleton argument 6 weeks ago.
Yeah.
The Secretary of State only objected to it 2 days ago, and you've responded in the document, which is on our...
Precisely, and making our application.
Right. Okay. So you're seeking to maintain your replacement skeleton argument as it sits in the bundle.
Yes, precisely.
Right. Well, in that case, we don't need to read this for the moment because we'll look to Ms. Massoud for some help. Thank you.
Thank you.
Right. So what's the problem with the skeleton argument that was objected to 2 days ago?
I can deal with the point briefly. I don't want to take up too much court time with this, but essentially, as my lady and your lordships will know, a replacement skeleton is a skeleton which updates the references to the bundle. The skeleton argument that was served on the 7th wasn't a replacement skeleton; it was an entirely new skeleton argument. So, in other words, it was a supplementary skeleton argument, which the practice direction to Part 52C says requires permission of the court. There wasn't an accompanying application to rely on it. And so we simply brought that to the appellant's attention, or the attention of her representatives. The approach that was taken was unhelpful because when the replacement skeleton was sent, the email serving it didn't draw attention to the fact that it was it was an entirely new skeleton argument to the one that had been relied on previously, which had been prepared by my learned friend's predecessor. That meant that those instructing me, and this was unfortunate, didn't open the document thinking, well, it's just the same skeleton but with references to the bundle. And it was only when I started preparing for the appeal, did I realise that actually the appellant was seeking to rely on an entirely new skeleton argument for which they need the permission of the court. So that's the point.
I see. It's because of the way in which the bundle has been compiled with documents being piled at the back of it and so forth. And I've moved everything electronically to where I can use it. It hadn't been apparent until I now see your skeleton argument, which you were responding in effect to the PTA skeleton argument, is 24th of June.
Yes.
And then you awaken to the fact that that the replacement skeleton argument isn't a replacement skeleton argument, but a new skeleton argument.
A skeleton argument. Which...
Right. So stepping back from that, are there any points of substance that arise?
The appellant needs the permission of the court, and it's entirely a matter for the court.
But I mean, we're not going to refuse permission for the document to go in simply because it's in breach of the rules, having got this far. However, if there is anything that causes your client difficulty, then we need to know what it is.
Well, there is the skeleton argument I say does raise a new point. So even if it does raise a new point, right? And that's at paragraph 16.
Right. So we look at the
page 175.
175. You're singling out paragraph 16.
Yes, I mean the point is made later on, but it's encapsulated and made for the first time at paragraph 16, which is that the respondent ought to have either interviewed the appellant or followed a written and minded to process before making a final decision. Right. Now, the second point, that the fact that the respondent ought to have followed a written and minded to process, that's encompassed, we accept, in the ground of appeal on which this court granted permission. The first point isn't encompassed.
What do you call the first point? Interview.
So it's the failure to interview.
Right. So failure to interview.
Yes. And you'll see, if you look at page 22, that the way... Page 22 of the bundle, that the way that the point or the ground was put at the permission stage, paragraph 13, was as follows. The respondent... Paragraph 13, respondent in their email dated 7th October made no reference to the previous refusal letter. Therefore, the appellant was not on notice that she had to reply to a new allegation of non-disclosure of previous refusal letters while submitting evidence in the statement dated the 10th of October. So it's a narrow point about Secretary of State's failure to notify her. Sorry?
It's notify, not minded.
Exactly. Well, notify, except that's essentially what's often referred to as a minded to process.
What is a little unsatisfactory is the fact that a Balajigari point was taken in the grounds as originally formulated, but not this ground. This is part of ground 1. The Balajigari point was taken in relation to a completely different ground, in fact. But I mean, we are where we are.
Yes. I mean, I'm not going to suggest that we didn't understand the appellant not to be advancing the second point made at paragraph 16 of the skeleton, which is that the respondent didn't notify her in writing or give her advance notice in writing of the point or the respondent's concern about her failure to refer to the previous visa refusal. But we say that the point now being made that the respondent in the alternative ought to have interviewed her is a new point, which isn't encompassed.
But it's a new point of the sort that you can deal with by saying that that's a new point. It's not a new point that causes you to have to go away and take down books or take instructions.
It certainly doesn't require me to take instructions. It does require me to
Think.
and perhaps take you to a few more paragraphs in the relevant authorities.
Yeah. But I mean, in the end, I mean, I'm not meaning to describe the if there's been an improper procedural step, which we hadn't appreciated until now. Obviously, not assuming it was improper, but things being as they are, where do we go from here? Do we not just hear the argument and hold in mind what you're telling us? What's the alternative?
Well, the alternative is not to permit the appellant to advance any arguments on the interview point, but I've made the points I have, and it's...
Well, if it comes down in the end to the interview point, at any point in which we are addressed on interviewing, then a red light will go off and we'll start to think about whether we should be thinking about this or not in the overall circumstances. But
Very well.
Is that good enough for the Secretary of State for the purpose of progressing the appeal?
Yes, we're happy to proceed on that basis.
Yes, thank you very much, Ms. Masood. Now, in fairness, before you launch on the proper argument, Mr. Pasley, is that good enough for you?
I'm very grateful, my lord. Yes.
All right.
Yes.
So you have permission to rely on your on a supplemental skeleton argument. Describing itself as a replacement skeleton argument. And we don't need to read out at this stage the details, but the order will reflect this. And we may have something to say about what replacement skeleton arguments actually are, which is that they're not supplemental skeleton arguments under a false flag.
Yes.
I mean, if you want to say anything about that now, it does appear that that's what's happened here.
Yes, my lord, I've addressed that in my application.
Well,
for seeking
again,
permission.
because we don't want to dive into another document unless we want to, but are you accepting that you should have sought permission to appeal for this fresh document?
Permission to rely on the fresh document, my lord.
Yes.
Yes.
Sorry, did I say appeal? I meant
Yes.
permission.
Yes, certainly, my
You
lord.
should have sought permission for
Yes,
that.
well, it was an error, my lord, in labelling, and I'm sorry.
Well, it's not an error in labelling. I don't care about the label. It's an error in not having sought permission to have
Yes.
filed a document.
Yes, absolutely, my lord.
And
yes.
you're not challenging that.
No, my lord, no, absolutely, my lord.
Right. Well, I think that we should have applied for permission.
Yes, my lord. And I did say orally, my lord, today.
Yes.
Yes.
Right. Well, let's put that in a box and come to your appeal proper.
Thank you, my lord. Very grateful. My lord, in this appeal, there is one ground of challenge, and that is, as I have set out in the amended skeleton argument, that the Upper Tribunal, this is page 168 of the bundle. If you have the document separately, my lord and my lady, it's paragraph 6 of the skeleton. The subheading or the heading to paragraph 7. That the Upper Tribunal failed to appreciate that the respondent decision is in breach of the common law standards of fairness and or procedurally unfair on the grounds that prior to making a finding of bad faith in or a finding of acting disreputably, it failed to invite the appellant to respond either in interview or in writing to her failure to declare the 2010 visa refusal in her application form or failed to mention that in the materials provided in support of the application.
Will no doubt identify the finding of bad faith or the finding of disreputable behaviour for our benefit.
So, sorry, my lady. Okay.
You'll no doubt in your submissions come on to identify
Yes.
the finding of bad faith or the finding of disreputable behaviour.
Yeah, that's my lady, certainly. And also, my lady, the decision letter on page 77 of the core bundle. On the fourth bullet point, which is where the adverse findings begin necessarily, the Secretary of State finds, when asked on your visa application form if you have ever
You
been...
don't have to read it out.
Oh, great.
We've read it and see what it says.
Thank you, my lord.
It says it undermines the credibility. Is it your submission that a finding that something undermines somebody's credibility is the equivalent of a finding of disreputable behaviour or dishonesty?
Yes, my lady, because if one looks at, my lady, the sentence after that, it says, therefore, I'm not satisfied that your intention to visit the UK is genuine and that you intend to leave the UK. So immediately after the credibility finding, my lady, then it goes to the genuineness issue. So credibility on its own, I accept, my lady, is not always sufficient.
So if it had stopped at this particular matter undermines your credibility, would you say that that was a finding of dishonesty?
No, my lady, no.
So it's the juxtaposition of the undermining of the credibility and the lack of satisfaction that the intention is genuine.
Yes, my lady.
I mean, that is the reason that is given. I mean, it says, therefore, in other words, it's the only reason, as I read it, that is relied upon for the conclusion that the applicant is not genuine in the stated intention. The only reason is the one that's previously stated, isn't it? That's what, isn't that?
Yes,
the meaning of the word therefore.
Precisely, my lord. And I think, my lord, the key point here is that the conclusion that I'm not satisfied that you intention to visit the UK is genuine is based entirely on this premise of the failure to declare the visa application. And so...
Well, in that bullet point it is. It isn't in the last bullet point.
Yes.
Nor indeed the penultimate bullet point.
But it seems, my lady, my submission, that the other conclusions are influenced by this finding, because what the Secretary of State is saying here, almost independently of any other reason in that particular paragraph, that I am not satisfied that your intention to visit the UK is genuine, and that you intend to leave the UK. And at the end of the last bullet point, which looks at the various reasons identified, the Secretary of State concludes, I'm not satisfied that you have accurately presented your circumstances or intentions in wishing to enter the United Kingdom. This undermines the credibility of your application to the extent that I'm not satisfied that you are genuinely seeking entry. In my submission, that conclusion, again, is influenced and perhaps based in material part on the observation, the first material adverse observation in respect of the failure to declare the visa refusal.
Well, if you look at the earlier bullet points, one immediately above, I am not satisfied that the balance in your account reflects your usual financial position. I'm not satisfied that your personal circumstances are you have indicated. Therefore, I'm not satisfied that the documents you submitted demonstrate your circumstances. This undermines the credibility of the information. Now, doesn't that tie in with the I am not satisfied you have accurately presented your circumstances?
I accept, my lady, that other reasons are provided upon which credibility and genuineness is undermined.
All of each one of which are independent of the other, aren't they?
It is right, my lady, that the independent reasons on their own take issue with credibility and genuineness. But nonetheless, in respect of this this issue, my lady, this is as I say, where adverse findings begin, and where it is concluded that the first of all, credibility point, my lady, which I accept is not on its own sufficient, but then the concluding point that they are not satisfied that your intention to visit the UK is genuine and that you intend to leave the UK after a limited period.
Is your argument that the other reasons which are given in the paragraphs on page 78 are not capable of standing independently of the paragraph that you criticise? I mean, or are you saying that the paragraph you criticise casts any doubt upon the following paragraphs?
Yes. So, my lord, it's difficult to appreciate what the decision maker might have meant, but in relation to the paragraph that I rely upon, that suggests that the other paragraphs are influenced as a result of that finding of the first finding of credibility, and the first finding that she is not a genuine visitor.
I mean, if there were, let's say, 4 independent grounds, one of which was vitiated by procedural unfairness, but 3 of which were not, then, in a sense, a successful appeal would go nowhere.
If my lord, the court takes the view that there has been procedural unfairness, that's an important point of principle. That, in my submission, that if the decision maker had followed that process, then it does not follow that the application necessarily would have been refused.
I was postulating a case. Let's take it away from the facts of this, just as a matter of concept.
Yes.
Let's say there are 4 independent grounds.
Yeah.
And it's apparent that they are independent. You can see that one of them is vitiated by procedural unfairness, but 3 are not. Where would an appeal in that circumstance go, if anywhere?
My lord, the court will deal with that ground, and then the question will be a question of relief as to whether to remit. Is your point, my lord, whether the outcome would be highly likely to be the same? Is that the point, my lord?
Well, I think what's being put to you by my lady, and better than me certainly, but is that even if you were right on your criticism of the paragraph which straddles page 77 and 78, there do seem to have been other grounds which are not the subject of an appeal for the conclusion reached in the final paragraph. Yes. And I think, if my understanding is correct, trying to tease out, therefore, what consequences follow. Are you saying that we can see that your criticism of the ground that straddles, of the paragraph that straddles page 77 and 78 infects the other findings, or stands separately?
Yes, so my lord, we didn't have permission to rely on the other grounds. I mean, the skeleton argument, the grounds that were drafted were more than just the procedural issue point. But my submission would be respectfully, my lord, that if the court is with the appellant on the sole ground of challenge, then necessarily the other findings are infected because of that overall credibility finding that was made in that paragraph.
But how do you tie that? How do you make that point good on the wording? I mean, you assert that that's the case.
Yeah.
Looking at how is that so?
To join in, there appear to me on a straight reading of this to be 4 grounds on which you were knocked back.
Yes, that's right.
And each of them end with an expression of satisfaction that the intention was not genuine. The other 3 don't appear to be related either to each other or to the one which we're focusing on. There are 4 independent reasons here, aren't there?
Yes, my lord. I accept that, my lord.
I mean, you would have to show that any one of which might have been good enough, or appears in its terms to be good enough to have led to refusal, that those were so infected by whatever went wrong in your submission with the first one.
Yes.
That they fall away, because otherwise we couldn't remit, because it would be pointless.
Yes, I see the point my lord makes, and I'm grateful for also those observations. May I just have a moment, my lord, just to read it?
Yes, I mean, I'm looking essentially because of the formulaic way in which it's done. It's the last sentence of each of the 4 bullet points, beginning with the one that straddles the page. And then the last one is pulling matters together.
Yes. So, my lord, on page 78, the first bullet point.
Yes.
On that independent page, that, my lord, deals with the concluding bit of the paragraph is that taking all this into consideration leads me to doubt the intention. So that again refers to intention.
You have to continue.
Yes.
Because the conclusion, which is fatal is in the second half of that sentence.
Yes, yes, I see that one. I'm grateful.
And I mean, it's repeated in the next paragraph and the paragraph after that.
Yes, yes, and I see that, my lord.
And I think
yes.
well, I don't want to divert you from your course, but and this may not be true, but it seems to me that those are very great difficulties for your appeal.
Yes, I see them, my lord.
I suppose you would say, Mr. Fasley, that the concept of procedural fairness is so fundamental to the right to a fair disposal of a matter that once it is concluded that there has been substantial or material procedural unfairness, it wouldn't be right to let that go unmarked, because there's no knowing how far that unfairness has infected the way in which the decision maker has looked at the other issues. And if, as you say, it's the first point that they take, you might say to us, well, Court of Appeal, you're placing too high a burden on your client to show that it would have made a difference, because nobody will be able to tell unless you go back.
Yes, I'm very grateful, my lady. That's precisely what I'm grateful for his observation.
I think that's
the point
probably
that
the
I made.
best that you could put it, isn't it, Mr.
Yes,
Fasley?
yes, precisely, my lady.
So, and it could, for example, to pick my lady's point up, I mean, if the paragraph that straddles the page was the penultimate paragraph on page 78, not the first of the points made,
Yes,
your case would be materially more difficult, perhaps.
I accept that entirely.
Yeah, but it's the first thing that you come to.
Yes.
And the danger is that having formed that view in a procedurally unfair manner,
Yes,
the decision maker doesn't come to the other grounds with an open mind.
yes, precisely. My lord, that's the point.
All right.
That's the risk.
I think that's been very, very helpful for us to frame this.
Yes, I'm grateful, my lord. Yes.
But shall we then get down to considering whether this was in fact procedurally unfair, what
Yeah.
appears in the first bullet point, or whether it's something that was within the Secretary of State's rights, bearing in mind the process that had been set up for these applications.
Yes, I'm grateful.
Right.
My lord. My lord, moving to paragraph 8 of my skeleton argument,
That's on page.
169.
Thank you.
Thank you. My lord, that makes the point that that we just made earlier, that the particular wording of and the language used in respect to that bullet point, that amounts to an allegation of bad faith or of disreputable conduct. So we're not saying, my lord, that this was an allegation of dishonesty and that it was an allegation of bad faith, which is that you intend to come here not as a genuine visitor, and that you will not return at the end of your visit, is the implication of the finding made in that bullet
Well,
point.
isn't that the implication of the overall finding on the basis of all of the evidence as well?
It is, yes, my lady, I accept that.
So why do you say that this particular finding in relation to non-disclosure is different from all the other findings which lead to that conclusion?
Yes.
What's special about the failure to declare a previous visit?
That, my lady, sort of that contained an element of intention, because the way that the refusal letter is phrased, my lady, implies that there was a deliberate failure to declare a previous refusal. So where it says, my lady, that your credibility is undermined, and that on this basis, and that the intention is not genuine, that implies that the appellant has deliberately failed to declare her refusal.
Well,
It doesn't. Surely it implies that she's not reliable. It may imply more than that.
Yes, my lord,
But
yes.
essentially, if you let somebody visit as a visitor on the basis that they're going to be going back, you have to have a level of trust. And you tend to trust reliable people, and you don't tend to trust unreliable people. And so even if one takes at face value your client's position that she'd simply forgotten, not only about 2010, which is cited here, but it appears from the papers we've read that there was a previous application in 28.
2008 and 2008.
Yes, that's right, yes.
I mean, that clearly raises questions about the applicant's reliability. It doesn't necessarily have to raise questions about her honesty. I mean, what can happen, presumably, with visitors is not every visitor who gets a visa and then manages to beat the system comes here and stays and always intend to do so. Plenty of people come here and find they like it, and think, well, actually, I didn't intend to stay, but I think now I will. So why is this not framed as being a comment on credibility leading to conclusions about reliability rather than dishonesty?
Yes. My lord, credibility can necessarily mean honesty. So if somebody's not credible, it may be that they're not honest.
Well, I could say I'm not a credible witness because although I spoke about what was happening, I wasn't paying attention.
Yes.
But as I understand it, so I thought in the centre, as I understand it, you say, look, it says this type of discrepancy undermines the credibility of the information. Now, if it had said reliability, that would be different, but it talks about credibility, which is generally thought to be a question of whether somebody is believable. But it's, as I understand it, your argument is it's what follows. Therefore, I'm not satisfied your intention is genuine. It's if it had said I'm not satisfied, if it had stuck to reliability, then as I understand it, you probably couldn't be running the arguments you're running. It's because it's tied to credit and genuineness of intention that you say cast doubt upon the honesty, genuineness of the applicant. That's my understanding of your argument.
But precisely, my lord, yes. And it talks about information provided. And so it again, it's not clear, my lord, as to whether it talks about the information in respect of that declaration.
Well, exactly, and that's what I wanted to ask you about, Mr. Fasley, because I completely understand the strength of an argument that the Secretary of State has taken a point on a non-disclosure.
Yes.
He said, you failed to tell us X, and that undermines your credibility. And somebody says, well, I didn't have the opportunity to tell you X. And you should have given me the opportunity to tell you X before you start saying that I've deliberately withheld it from you or whatever. I understand the strength of that completely. The problem, it seems to me, and I need some help from you on this, is that there was an express question on the face of the application form, which your client answered, and I'm using a neutral word, inaccurately. She was asked in terms to cast her mind to whether or not there had been a previous refusal of a visa application. She answered it no. And at the end there is a declaration which says, if you give inaccurate information, we have the right to refuse. Now, that's the first limb of what the officer is saying in this case. The second is you compounded that by not referring to it again. And I'm looking at those two things together to look at genuineness. Now, what's bothering me is why what was on the face of the form wasn't enough to put her on notice that she should tell you about it.
Yes, my lady, I'm grateful. That's, my lady, where if you're with the appellant that procedural fairness was triggered at the time that the suspicions were raised as to credibility of the information and the genuineness of intention, that if she had been given the opportunity to explain, then she would have explained so. There could be all sorts of reasons, my lady, why there was an inaccurate declaration. I've alluded to the passage of time.
Sorry. I think you're misunderstanding my question. My question is this. Given that she's been alerted to the fact that this is important information on the face of the document she signed and told about the consequences, why does she need to be alerted to the point again as a matter of procedural fairness?
I go for my lady. So at the time that she was alerted, my lady, within the application form, no concerns were put to her as to the credibility of the information that she had provided. And it's only when, she became aware for the first time, as I understand it, my lady, when the refusal letter was delivered, that there has been an allegation raised, which we say is one of bad faith.
So is it your submission, forget that this is the third time along, right?
Yes.
If the person who made the decision back on the first occasion in July 2021 had sent back a refusal letter to your client saying exactly what's said here, which is you did not, you ticked the box in the wrong, and it says no, and we found out that in fact you did have it. Is it your submission that in that scenario it was incumbent on the Secretary of State, having noticed that the box had been ticked in a particular way, to either interview your client or to send a minded to letter?
But if this issue was raised in the first refusal letter,
Yes.
then in my submission the principle would apply in the same way. But if she had applied the second time and explained this discrepancy, then it wouldn't arise.
So it's yes.
So in every case, is it your submission that in every case where somebody answers a question on the application form, which is no, and that is an inaccurate answer, with that on the bottom of the form, before the Secretary of State uses that as a grounds for saying it undermines your credibility, they've got to give them an opportunity to explain why they got it wrong?
No, my lady. My lady, procedure of fairness is fact specific and depends on the context.
Right.
However, unless the evidence is very strong of that they justified the finding, then it may be argued that the procedure of fairness argument is not strong enough to warrant the giving of a notice. But it'd be very those would be rare cases, my lady, according to authorities.
You said generally.
Yes.
Right. Yeah. So generally, in every case where the Secretary of State is minded to refuse an application on the basis of inaccurate information, they should give the applicant an opportunity to explain the inaccuracy.
Yes, well, where they've made a finding or an allegation of either explicit or implied bad faith or acting disreputably.
So do we actually have the statement to which my lady has referred in the bundle somewhere, the one that's put on the bottom of the form?
Is that, my lord, the statement from the appellant, the witness statement?
No, the statement on the face of
The actual
form.
original document.
It didn't make its way into the bundle, but I have copies.
All right, could we see those, please?
Yeah.
Thank you.
Because
Thank you, Archie.
my understanding is that you say that.
Sorry, my lord.
Let's wait until we get this document. I think it's probably better before I ask the question.
Yes. Could we see the document, please? Thank you.
Just to explain, the reason it says Appendix O at the top is because this document is appended to the Secretary of State's summary grounds of defence.
Yes, all right. Thank you.
It's page 6, my lords and my lady, of the application.
No, it's the penultimate paragraph on page 11, isn't it?
Page 6 is where the
Yeah.
question is asked.
Yes, but the declaration is at the end.
Now, it says, I understand if false information is given. The use of the word false is an interesting word. It's not saying inaccurate information is given. It's if false information is given. Does that carry the connotation that it's deliberately inaccurate? And false is a stronger word than inaccurate, I think, isn't it?
Yes.
I mean, is there any? I don't know. I don't know whether there's any learning.
I think there's a prior bit, isn't there? That it's not. That's to do with prosecution. It's
Well, it's
immediately under the word declaration on the previous page.
Confirmed that to the best of my knowledge is correct.
I understand the data can be used, and then it says, I thought the paragraph the lady was referring to, I understand that if false information is given, the application can be refused.
Yes.
And my question as a ignoramus in this area, or at least in relation to this form anyway, is whether there's any learning on the question of false as opposed to just inaccurate.
Yeah, and say A.
Yes.
It means dishonest.
It means so the question, as I understand it, it's not really said if you give inaccurate information innocently, the warning isn't you may be refused just for giving inaccurate information. The warning is if you give false information, give inaccurate information deliberately, then your application can be refused. So as I would understand it, the question of deliberateness is in play right from the start. And that's why you say, I think, irrespective of the way it's put, that if there is going to be reliance on inaccurate information to refuse, the question of whether it was done deliberately or accidentally should be raised with the applicant as a matter of fairness before that's treated as a ground for refusal.
Yes, my lord. That's fine.
But of course, a finding of dishonesty would have all these connotations that are mentioned here.
Yes.
And that includes the 10-year ban.
Yeah.
And nobody's ever suggested that that's going to be operated in relation to your client.
No, my lady, that's right. But the finding is nonetheless, my lady, one of integrity, because it implies respectfully that the declaration was either done because she was reckless, or that
Negligent?
or negligent. Yes, my lady.
Well, why does that impact on somebody's?
Because it's tied
integrity?
into, my lady, the genuine intention point.
Actually, I don't believe you're actually making that. That's not your submission. I mean, I think you say that it must follow because it goes to the genuineness that the assertion is not just that it was a negligent, careless failure. It's something worse than that because it goes to the genuineness of the intention. So I'm not sure you answered the lady's question correctly.
Yes, I'm grateful, my lord. Yes, so that her genuine intentions as a visitor and her genuineness and the information she provided was undermined, and on that basis, therefore, that's an allegation effectively of bad faith.
Could we look, please, at the actual rules here? I think you will know better than I do, but page 8 of the authorities bundle. Can you just confirm that this is what we are talking about? Genuine visitor requirement.
Yes, my lord.
So the whole decision-making process in this aspect is framed with relation to whether somebody is a genuine visitor. And one sees genuineness appearing in the second line of that paragraph, one sees it appearing in point C, and I can't remember, was it B and C that you were refused under?
Or was it A C?
A and C. A and C, right. So both of those are under a rubric of genuineness. So it would seem that your submission might amount to, I want to fully understand what it is because we've been considering this, to the fact that if you were ever refused under 4.2a, B, C, or indeed any of them, that would be such a slur that you should have the chance to be consulted about it. How can it be? How can it be otherwise?
I go for my lord. So I'm not, my lord, making the submission that in every case where genuineness is doubted, there should be an opportunity to give notice to explain any issues of.
Right. So whatever it is, however you ultimately frame your submission, it's that under any refusal under V4.2 has got to have an element of procedural fairness, which means that in, as I think you put it, generally or in almost all cases,
Yes.
the person must be told in some way or another, or given an opportunity to rebut the conclusion of lack of genuineness. Is that what it comes to?
My lord, if for example, the case, I mean, in this case, there are issues taken with the other points, my lord. So I'm not arguing that those necessarily required a notice to have been given. For example, taking an issue with bank statements or credibility.
No, I'm talking about. I understand that that other parts of the reasons didn't fall within.
Yes.
Yes, these particular provisions, but where they do, I mean, if your submission is correct, then it would have to follow, wouldn't it, that everybody who is turned down on the basis of this provision 4.2 is entitled to be heard before a final decision is made. In other words, the form isn't enough. They've got to also have a chance to make supplemental submissions in one form or another.
If they can satisfy, my lord, that there was an allegation implicitly at least of bad faith or of acting disreputable.
Because it would seem that if anybody is turned down under your analysis of this, it seems if anybody's turned down under this, it would involve whatever one calls it, dishonesty, disreputability, and so forth. And I'm at the moment, as you can see, having difficulty with that because it's not that they're asked to decide whether you're an honest person. They're asked a simple question, which is, am I satisfied that ... he, she is genuine.
Yes, my lord. My lord, the use of language is important, and that could imply potentially the connotations that were attributed to the findings. And we say that this particular paragraph dealing with this issue
does.
It does, yes.
It does. So it's not enough for the decision maker saying, I'm sorry, I've thought about this and I'm simply not satisfied.
It'd be one thing to say, my lord, that the one's not satisfied with the reliability issues, but if
I'm not satisfied of the criterion which has been set down for these visits, does that bring with it a connotation of disreputability, or however one describes it?
It's also sorry.
It might or it might not. I mean, just look at the bottom of E. The applicant must show that any funds they rely upon are held in a financial institution permitted under FIN 2.1 in Appendix Finance. Let's assume that somebody puts a form in and fails to show that because the funds are held in a non-permitted financial institution. Does that, I mean, I asked, does that mean that they must be acting dishonestly?
No, but it's the headline. No, it's the headline. I mean, these are just subparts of the overall conclusion that has to be reached.
It's a curiosity because some of the things would seem to go to genuineness in
intention,
in intention and honesty, and some of them seem to have nothing to do with it.
Yes.
If I can put it that way. I mean, whether you have your funds in one institution rather than another may have nothing to do with whether you really, genuinely, honestly intend to leave or not. You just made a mistake. I mean, I find this quite a difficult rule to
Yes.
get my head round.
Yes, and that's, my lord, where the difficulty is that it is much. The law is much more clear when it comes to dishonesty. When it comes to the Carragher line of authority, in respect of disreputable conduct or bad faith, it's much more tricky. In this particular case, my lord, what is useful, my lord, to note that at the penultimate bullet point, the conclusion is that I am not satisfied that you've accurately presented your circumstances or intentions. And again, the word of the accurate, my lord, is an important one, because part of that conclusion is based on the non-declaration of the visit visa refusal, and that again, the finding looked, for example, my lord, in the context of disciplinary issues, saying somebody hasn't accurately presented something, it is an integrity issue, and so this decision would imply that the appellant did not have 100% integrity in her application, because the accuracy of information that she provided were questioned without giving her the opportunity to present itself, and particularly, my lord, in respect of the declaration failure, because that's distinct from any other sort of kind of defects or deficiencies in the documentation, and it's generally understood that that if somebody's failed to declare something, that you can go to their honesty and integrity.
Right.
Thank you, my lord. My lord, I've set out the paragraphs from Carragher in respect of bad faith and active disreputability. I need not take my lord's through those. I'm sure the court has read those.
Any particular part of Carragher that you specifically rely on,
Yes.
that you want to address us on?
I agree. It's paragraph 103 of Carragher on page 156 of the authorities bundle.
There's a certain tension, I should tell you, I think, between Mr. Justice Saini's summary at 103 and Lord Justice Green's judgment in Taj, which of course is the superior authority.
Yes.
But you'll no doubt.
Shall we look
come
at
on
both of them, because my lady is more familiar with these
Yes.
than I am. So now, where are you alighting in 103 particularly?
In particular, my lord,
Paragraph 1, is it?
paragraph 1, yes. And you'd see, my lord, the point about that common law fairness will generally require at least the following safeguards. And then it sets those out.
As an applicant for a right, a benefit, or a status, which of those is this?
It would be, my lord, my lady, benefit.
Yeah.
To come, yes. And at paragraph 3, my lady and my lord, it says that the need for these common law protections is particularly acute where there has been a decision by the legislature to remove the appeal on the merits of an independent and an impartial tribunal. And there is no right of appeal in a case like this, and no administrative review either.
So they should be given an opportunity to address the claimed wrongdoing or make representations on the specific matter.
Yes. I mean, it may be, my lady, the court may take the view that the standard safeguards of procedural fairness are not applicable on the facts, but that there has to be some form of process. For example, by means of writing, not in the same way that a dishonesty allegation would have to be put in particularized, but some form of notice that we're concerned about this. Can you explain? Even if only, my lady, in writing.
So something along the minded to process, you say?
If my lady's not with, the court is not with me on the traditional process of procedural fairness applies, and the minded process doesn't apply, then there has to be some process
Right.
What sort of a minded to process are you suggesting?
That at the very least, so we know, my lady, that for an allegation of dishonesty has to be particularised and properly set out. But for something like this, which is much less clear, that there's simply a notice is given in writing to say that you failed to
We're
declare.
concerned that you didn't do this.
Yes, and do you have anything to say about that before we make a decision? Just very briefly.
Okay.
Thank you. That was, my lady, paragraph 106 of Carrigal.
It's really what you're arguing for is deferral. Is that what it comes to, really? It's deferral to allow for the provision of further information.
Yes, but before an address findings made in respect of the issue, my lord, yes.
It's an opportunity.
Well, and a notice, yes.
Opportunity to deal with it.
Yes, precisely, yes.
Those are the words I think I used in
Yes.
Tamina.
Yes, of course.
Yeah,
And I
without
accept.
being prescriptive. It's just
Yes,
you have an
I agree.
opportunity. If somebody's going to make a finding against you, you have an
Yeah.
opportunity to deal with it. That seems to be part and parcel of fairness.
yes, and I accept, my lords, my lady, entirely that that in a dishonesty case, the safeguards are much they're much stronger, and they apply generally in all cases, perhaps in all cases, yes.
Right, and just pausing
Yes.
to consider the consequences for this case.
Yes.
As I've understood reading her statement, the applicant's position is that had she been asked, she would simply have said, "I forgot."
I'm not entirely certain, my lord. I've sought instruction on this point, but she would have provided an explanation as to why that error occurred.
Well, she's filed a statement.
She has, yes. Just check that. 68. Page 68, my lord. And paragraph 10, on page 69.
Would it then have been open? Let's suppose it I
I'm
just
just
want
going to look at this paragraph. Is it just paragraph 10? That's the only paragraph I've.
I do not recall it.
Yes, I think that's right.
And 14.
Sorry, thank you.
Sorry, what page were
13
you on?
years ago. I don't
69.
have a record.
69.
I mean, of course,
One
that
of these.
I mean, there might be circumstances. No offence intended to anybody in this case, where, for example, one would say, I filed an application. They've shown me I filed an application. I've had a stroke, and I simply didn't remember when I applied this time that I had applied before. Now, that might raise a point in your favour, as it were, that the system should
Yes.
account for that.
Yes.
But it doesn't help your client in this case, happily.
No, my lord, yes, that's right. Yes.
It's just as I forgot.
And again, my lord, if an opportunity was provided, she would have had to sit out in full, because this is post decision evidence, which isn't particularly
No,
relevant.
but it's a little difficult to see how she could have elaborated on the information that she
Yes.
gives there.
But it would have been, my lord, that the process would have been followed, and then that finding would have been very safely sustained, whatever the outcome.
Right. That sort of presages what I was going to ask you, because you would accept that if the process was followed and the opportunity was given to give an explanation, if the decision maker didn't believe the explanation that was given, you wouldn't have to have another bite of the cherry.
Absolutely, my lady, yes.
Right.
And the only challenge will be on public road grounds if that finding was unsafe for some other
Right.
reason.
Right.
And my lord, my lady, there is one other point. In this application, before the current refusal, the Secretary of State wrote to the appellant and or her representatives and sought further information. That request is,
This is the 7th of October letter.
I believe it is. I'll just-
It's the one that asked if you want to give us an update on your circumstances, because the original
Yes.
decision was some time ago.
Yes. That is correct.
100.
Yes, great. And this was in circumstances that the consent order that was signed did not make a provision for the provision of additional documentation. And that consent order is at page 102. And we know from...
You're not complaining that the Secretary of State gave your client an opportunity to put in some further information about any material change in circumstances, are you?
No, on the contrary, you're very grateful for that. The point was that that this concern could and ought to have been pointed out, particularly because the Secretary of State had already gone into the expense and the time of writing, and they could have simply said that we're concerned about this. What do you say about that?
Well, when this was written, how do we know that they'd even started reconsidering the decision?
Oh, I see. Yes, I'm grateful. That is a point.
Well, it sort of says we are in the process of reconsidering your application.
Yes,
I didn't see that.
I'm grateful. Thank you.
So, I mean, as I understand it, they say we are in the process of reconsidering. Give us recent documentation or a possible change of circumstances. I mean, under no reading of that, as I understand you say, under no reading of that, was that a suggestion that anything needed to be said about a refusal back in 20 whenever it was.
Yeah. Yes.
The whole background to this was you JR'd on the basis of financial information not being adequate, or the conclusion that the financial information wasn't adequate was open to challenge.
Yes.
And the Secretary of State said, fine, don't go to, we don't need to go to the wire on this, we'll reconsider. You get this letter saying, we are reconsidering, tell us if there has been any change of circumstance or recent information.
Yeah.
And you say, under no circumstances were you alerted
Yes.
to the need to say, oh, and by the way,
Yes.
the reason we didn't tell you about the previous refusal is that we forgot.
Precisely about it, and there wasn't even an implied.
But in fact, you were pointed in the different direction by the wording of what's in bold at page 100.
Yes.
I think that's what you say.
Yes, no, absolutely, my lord. Yes, and there wasn't even an implied assertion that there's anything inaccurate about the information in this chap. And the other point is, my lady, that the representations that were filed are on page 80 of the hearing. They provided the witness statement, and on page 81 it said, under additional evidence attached, the sort of penultimate paragraph on that page, our client would be
There is
willing
no
to address.
adverse change, etc. Yeah.
Sorry, 82, did you say?
81.
81.
Is it under the heading additional evidence?
Yes, the last paragraph.
Confirm there's no adverse change in circumstances. We invite you to proceed on the basis that the circumstances are the same as at the decision of the refusal letter.
Yes, and at the end of that, the last paragraph on that page, my lady says, our client would be willing to address any inquiries, issues and clarification should there be any.
Yes. But your solicitors are specifically asking the Secretary of State to assume that they should go back to the situation which obtained at the date of the refusal letter.
Yes, because they were never put on notice, my lady, of any issue in relation to a declaration failing.
Well, let's have a look at page 80, please. Second paragraph. It would be misleading and out of the vires of the consent order to treat this as a completely fresh application, whereby the entry clearance officer could choose to start finding new reasons for maintaining the decision date of the 29th of 11th. So, were your instructing solicitors not therefore anticipating that it was possible that in reconsidering the matter, new reasons might be considered?
It's tried, my lady, that the Secretary of State is able and entitled to make to provide new reasons, and so as a matter of law, they should have
That's sabre rattling.
Sorry, ma'am?
Sabre rattling.
Yes.
Well, we're just saying we don't believe. Well, we're saying we don't believe you're doing this, but just to make it clear, you shouldn't.
Yes.
That's what I'm saying.
Yes.
I mean, you presumably say that should have prompted the Secretary of State to come back and say, actually, we are. And we're entitled to.
Yes.
The Secretary of State could have said. If the Secretary of State had said, actually we are and we're entitled to,
Yes.
then you would have said, what? And then the whole thing would have come out. But your point is that none of this was ever done.
Yes, my lord. Whatever, my lord, the circumstances, if an application, if a finding is made that says impugns credibility in a way that makes at least implicitly an allegation of bad faith, then the safeguards of procedural and common law fairness applies. And the request made by the appellant's representative that if you require anything further, please let us know. In my submission was inviting Secretary of State. Again, if there was anything, particularly if it relates to the issue of integrity, then that should be flagged up, or at least some sort of notice provided. And the need in this case is more acute, respectfully, because they had engaged in this exercise very helpfully to ask for any change in circumstances, but had then not set out the material concern they had in respect to that declaration.
Well, it almost seems as if your submission amounts to this, that instead of that paragraph, your solicitors could have written and said, bearing in mind that it would be a serious thing to accuse my client of disreputable conduct, which you would need to do and to refuse on genuineness grounds again. Would you please disclose to us anything that might be relevant to that, so we have a chance to deal with it? I mean, isn't that the proposition that you would have been entitled?
Yes, absolutely.
To present to the Secretary of State if your submissions are correct.
Yes, precisely.
And your submissions having succeeded here, you would then cite this case as being the justification for it.
Yes, my lord. Generally, my lord, representatives don't. They wouldn't necessarily make submissions on procedural fairness unless a decision had arrived at. I mean, in this case, there were two decisions before this, but
is that relevant?
No,
because I think you accept, don't you, that the history, whilst it obviously created a degree of time lag, which gave rise to the request, have there been any material change of circumstances, what the Secretary of State was required to do was to treat it as if it was a completely clean sheet, and look at that application in July 2021 afresh, which on the face of it, subject to the point that was taken about the ambit of consent order, doesn't constrain her to the reasons that have been previously given for any refusal.
No, I agree entirely.
Yeah.
I agree entirely. I do that.
So really, I think what it boils down to is your primary submission that, irrespective of anything that's in the correspondence, there might have been an opportunity for the Secretary of State to have asked the question. She didn't.
Yes.
But irrespective of that, as a matter of principle, if you're going to make a finding that has an adverse inference of a lack of integrity, you've got to give somebody a fair opportunity to respond to it. That's really what it boils down to.
That's precisely it. Yes. And my lady, if I may say so, the fact that the Secretary of State has written to the appellant demonstrate her willingness to engage in a process to ensure that there is fairness.
Yes.
And so
it just doesn't go far enough.
Yes. Thank you. Ali, in relation,
just for a note, together with the paragraph you drew our attention to under the heading "Additional Evidence Attached," you see at page 81.
Yeah,
we do need to look at page 98, don't we? That's the statement that was actually made, which seems to be plainly directed at what had happened in the judicial review and the position in relation to circumstances and financial circumstances and expenses, or circumstances and expenses.
Yes.
I'm not making a point there. I'm just for completeness.
Precisely.
Just saying for completeness. Yeah.
Thank you. Madam my lady, the paragraph 106 of Carrigal on page 157. And subparagraph IX, which is on page 158. Yeah, I think this is where my lord, as my lord observed, the visitor rules are slightly different to perhaps other rules, in that Mr. Justice Saney dealt with the genuine intention or wish to run the proposed business point, and it talked about the need to interview an applicant, and then it goes on. At X, that is because the term genuine intention or wish are in context referring to.
Just before we go over the page, I'm sorry, you're reading 10. You're reading X? I see. No, okay.
Yes.
Well, that's because of the guidance, isn't it? Where one's dealing with business applications, there are all kinds of red flags that might arise. For example, concerns about authenticity of documents, internal inconsistencies, somebody else having a finger in the pie. All of that are the sorts of concerns whereby, in certain circumstances, if those flags are raised, Mr. Justice Saney says at Roman 11, it would be rare for it to be fair and lawful not to interview somebody if you're going to reject on the basis of no genuine intentional wish to run the proposed business.
Precisely, my lady. So he sets out, my lady, the general principles applicable to all kinds of cases, paragraph 103, and these are specifically in relation to the business, proposed running of the business.
Where there is an interview process.
Yes. If they so wish to, they can. Even my lord, in visit visa application, the secretary has discretion to choose to interview somebody if they wish to do so.
Balajigari says that you don't necessarily have to follow that process, even where the underlying suspicion is that you've either lied to the Inland Revenue or if you lied to the Home Office.
Are interviews mentioned in relation to V42?
I think there may be something in the guidance, my lord. Perhaps I can.
There's nothing in the visit visa guidance which is in the bundle. There is something in the guidance on general grounds of refusal.
On what?
On general grounds of refusal, which isn't in the bundle, unfortunately. It's not specific to visit visas, but it says something to the effect that because the consequences of refusing entry clearance are nowhere near as serious as the consequences of refusing, say, an application for indefinite leave to remain or leave to remain. Generally, even where there is an allegation of deception or provision of false information, interviews will not be held in entry clearance cases.
Can you run that down, please, and show it to us?
Yes, I can do. I can do it now, or I can do it in the course of my submission.
In the course of the day, I'm sure there'll be an opportunity.
Thank you, my lord.
Because I would assume that the bigger the decision, the more likely an interview process is going to be.
Precisely, and the severity of the consequences, my lord, is a key factor in all of this. The more severe the finding and the consequences, the more likely the defendants will. And Lord X, my lords would have read to my lady that just saying he said in that context that the term genuine intention or wish are in the context referring to a potential conclusion that the application is made in bad faith.
I'm not hearing.
Sorry.
Where are you reading from?
158.
Little Roman town.
Yes. Okay. Well, we see.
And he says not only is that the general English language meaning in this context of genuine intention or wish, but he also appears to be the understanding of the drafters of the guidance, referring to that guidance. Then on page 159 at XII, again refers to a lack of genuineness, which I say respectfully that is the conclusion reached by the respondent in this case.
Right, now that conclusion is specific to business applications in the context of a lack of genuineness. A very different view was formulated by this court in relation to a genuineness requirement in relation to the Tier 1 entrepreneur system under the points-based system in Taj.
Yes.
So how do you reconcile those two cases? Taj is at page 269 of the bundle, and you'll see that there are questions about viability and credibility of business and so on. And as I recall it, Lord Justice Green rejected the argument that there is a general requirement of fairness, that there is a necessity as a general point of view to follow a minded to process. Is that right?
Paragraph 63 to 65.
May I just maybe to read that one?
Yes.
And also 72 following.
Yeah, I think I had in mind 72.
Yes, I accept, my lady, that that it is a fact-specific exercise. The issue of procedural fairness. The authority, my lady, in the case of Carrigal, yes, that was before Taj, wasn't it, my lady? Yes.
And Taj is the
Yes.
superior authority.
It is, my lady, yes. As I understand it, my lady,
I think it rather suggests, doesn't it, that perhaps Mr. Justice Saini has put things a little too high in para 103 when he talks about the general principle, and that in fact it's not every case where genuineness or truthfulness or veracity or integrity arises that one has to follow a minded to process. It very much depends on the context.
Yes, my lady, I accept that proposition, my lady. Yeah.
A reconciliation is possibly, we find it in the word generally, in the statement of principle at
Yes.
103.1. He does say generally, and even in 107, he's talking about it's likely to be unfair, but he doesn't say it will be. And Lord Justice Green was just saying there is no immutable rule. It depends on the facts. I mean,
And context.
It depends on the facts and the context. Yeah. And Lord Justice Green was rejecting the assertion that in every case, come what may, if you've got doubts about credibility, you have to follow a process. Yes. And Mr. Justice Saini was saying generally, and you may not be able to, you're likely to be unable to show procedural fairness unless you do. But neither of them is taking an extreme position.
Yes, absolutely.
Is that a way of resolving it?
Yeah, yes, well, that's right.
Possible way, anyway, well, obviously. decide whether it is or it isn't, but
Yeah.
it's at least one possible way of resolving the tension.
Yes. What I would say, I already said that Mr. Hosseini looked at a range of authorities in his decision, including Balajigari, and then came to those conclusions. And as I understand it, Taj does not necessarily say that Mr. Hosseini was wrong in his decision. And invite to the court to take that into account. Melody, just on the on page 157 of the authorities bundle. Sorry, page 158. Mr. Hosseini was referring to the guidance in the business cases and then sets out factors that may give concerns for the triggering of the procedural fairness process. And one of the points is inconsistencies in the evidence provided. And one point is that the credibility of the application is in doubt. In my submission, although in a different context, but both of those reasons apply to this case. And the sort of reasons behind why procedural fairness is necessary are set out at 109 and 112 and 113 of Mr. Hosseini's judgment. Again, I'm sure the court is very well familiar with those.
Actually, it appears that Lord Justice Singh said something about it in Citizens UK, but I don't think we've got that in the bundle.
I think it's quoted somewhere in one of the other.
It's quoted at great length in
Balajigari.
at page 311.
Balajigari is certainly regarded as being the lead case in this field, isn't it?
Yes, but we're looking at 311, and then also the passages that are most relevant are on 313 and 314.
My lords and my lady, on paragraph 112 of Carrigal, the court held that the claimants were in substance accused by the Secretary of State of having effectively made an application with a claimed intention, which they did not in fact hold. That is effectively a conclusion of bad faith or of some form of disreputable conduct. Although in a different context, but in my submission that applies. And then he goes on, the Secretary of State did not believe them in their declaration. I've applied those at paragraph 17 of my skeleton argument, or I've sought to set out how those principles can apply to the facts of this case. I think I've sort of made out in my submissions. And at least the implied inference from the decision, my lords and my lady, is that the appellant has no true intentions as a genuine visitor to come to the UK and return at the end of her visit, but that she's using the application as a potentially erroneous basis upon which to remain on a long-term basis. And my lord, there is one other authority in relation to Carrigal that I consider to be helpful to the court. That's there's a case of Wahid on page 218 of the authorities bundle. Paragraph 32.
Sorry, Harry, can you go to the page again, please?
218, my lady.
18, thank you.
And in that paragraph, the court held, this court held, that
This is the bit that answers my lord's question about
Yes,
falsity.
yes, thank you.
I knew there was something
Yes,
somewhere that
thank you.
did.
Paragraph 30.
32.
Yes, I know, but
I'll go-
30 is the
yes.
one my lady's drawing my attention to.
I'm grateful.
Yeah, I was right. It was AA. Yes.
Thank you. 32 states, my lords and my lady, that where it was held, the procedural fairness requires, in that case, sorry, it was held the procedural fairness requires an opportunity to respond where the entry clearance officer harbours suspicions of dishonesty. And so the phrase is what I place reliance on, in that it isn't about where the ECO finds dishonesty, concludes dishonesty, but harbours dishonesty, suspicions of dishonesty. And so this would suggest.
The point is, if dishonesty is a relevant or indeed the important determinant, the point that's being made here is false means dishonesty, not merely inaccuracy. Therefore, that's the question.
Yeah, yes.
And therefore, in that context, if you harbour suspicions of dishonesty, because it's going to be critical to your decision, procedural fairness requires you to at least alert or give the opportunity to the person to deal with it.
Yes.
If it wasn't critical to your decision and you just thought, oh, I don't trust that, right, then it might not be quite the same thing.
Yeah.
But where it is actually the relevant factor.
Yes. Yeah, sure. Precisely, my lord.
That's the point.
Yes, my lord. And just my lord, just one observation that where it says harbours, and then that sort of supports the Carrick line of authority, which says that even if there's no conclusion of dishonesty, but there are doubts about integrity, then the procedural fairness can be triggered.
But just to test the point, and I don't know in a sense whether this makes a difference, but if the only question that was relevant to the decision that had to be made was the information accurate or inaccurate, the fact that you harbour doubts that the person may have been honest or dishonest, in a sense, doesn't matter. It's either accurate or it isn't.
Yes, my lord.
Where the critical question is it deliberately inaccurate, then you ought to give the person a chance to deal with it, because that's going to be what you rely upon to reach a decision. That's the point, isn't it?
Yes, absolutely, absolutely, my lord. That's.
But as I understand it, your submission is not that this is tantamount to an accusation of dishonesty, but one where it is suggested that there is a lack of integrity on the basis that there is a disbelief as to the genuineness of a person's intention.
Yes, my lord.
So you say that applies across by way of analogy to a case where the critical factor, you'd say, is a lack of satisfaction as to somebody's genuine intention.
Yes,
Yes.
my lord.
Just want to make sure I've got
Yes,
the
thank you.
submission. Yeah. So carries across.
Thank you.
The decision in Wahid is a permission decision.
It was a judicial review. It's one of those odd decisions. It was the appeal was allowed.
It was an appeal from the refusal
Refusal of
of
permission.
permission to apply for judicial review. So it wasn't a permission decision of this court, but it was a decision in relation to permission. And the paragraphs 33 and 34, Lady Justice engages in on a one hand and on the other hand analysis, saying that this deserves fuller debate. So we don't have the what happened.
I've taken instructions on what happened. The short answer is not very much. Well,
Okay.
in the
Right, it
sense
isn't
there's
that
no
we're
decision.
missing an important second
no,
volume.
You're not. You're not missing an important decision. It was settled essentially after.
Thank you. And do we have AA in here?
No, in the third respondent, no.
Well, it seems to
Is that A in Nigeria, my lord?
Can I also ask you about 29 and 30 of this decision? There's a specific, does V 3.6 concern this case?
The version of the rules in force at the time the decision under challenge was taken are different, and I'll take you to the relevant version.
I'm sorry.
The version of the rules in force at the time the decision in this case was taken were different.
So
there is no paragraph V.36 in
right,
that.
we're not concerned with the V 3.6, which is sort of an overarching paragraph by the look of it in relation to false information.
Yes.
That's the one that's in the general rule now, isn't
Yeah, so now the relevant part of the rule simply says there's a suitability requirement.
Yeah.
And that is that the applicant must comply. The application does not fall for refusal under Part 9, which are the general grounds of refusal. And the general grounds of refusal do include a ground.
I'm sorry, I'm simply not hearing.
I'm sorry.
No.
It's
Could you just start again and explain to us, was there any equivalent general provision that applied
Yes.
to the situation that this appellant was in?
the short answer is yes.
Right, and do we have it?
No,
is it
but
in
I
our
have a copy.
is it in our bundle? Because it looks on the face of it as if it is potentially applicable.
It's partly in the bundle. The other part I have a copy of, which I was going to hand up.
Right. Well, can we just go on for the moment and leave it to you to bring it up, and if there's any matter that needs reply, then you'll deal with it in reply.
Of course, thank you.
Great.
My lord, paragraph 21 of my skeleton argument, I've cited the commission decision from the Upper Tribunal, which deals with the minded to process point. I know that's a permission decision only. I'm going to rely upon it, my lord, because other than Carrigal, there appears to be a lack of authorities on the issue of bad faith. And
You're certainly going to show it to us, so let's have a look.
Thank you. Page 176 of the bundle.
Thanks.
Skeleton.
Sorry, is that right? 176?
It's the middle of the case.
That's the middle of Campos.
Oh, sorry. So 186.
186, thank you. Doesn't look much different.
Sorry, so we're in 186 of the court.
Sorry, yes, 186 is the decision of the Home Office in that particular case.
Stick to the call, sorry.
Yeah, and then I'll take a decision of the Upper Tribunal.
Yes. Looking in the wrong bundle.
So what are you showing us now?
My lord, I'm trying to show the reasoning of the Home Office on another case where the Upper Tribunal then held, I'll take a decision in a moment, that amounted to.
I see.
Yes.
So right, this is taken from Mr. ZG's decision letter of the 4th of April.
Yes.
Right. Well, let's just hear you on this. What is the point?
The point, my lord, is set out in paragraph 21 of my skeleton.
Right. Is it all about how far he was from Heathrow
Yes.
to the centre of London?
Yes.
Okay. So that was the context. Bottom of page 186.
Yes.
And what's the decision that you want to take us to?
Thank you. The decision on page 182.
Thank you. Oh, sorry, this is the court's decision.
Of course, yeah, the Upper Tribunal, yes. Paragraph 9.
They gave you permission to proceed.
They did.
So what?
Well, let's just read it first.
Yes.
Right, so this is a living example from the past year of permission being granted in a case that is in this general territory. Is that it?
Precisely.
All right.
That's the point. Thank you, man.
We see it.
I'm grateful. Thank you. My lord, I've made one point in paragraph 24 of my skeleton, which is a point that is about procedural fairness in the context of hearings in the tribunals. And the principle there is that if a decision maker is likely to make an adverse finding, then in certain cases a material issue should be put to a witness or an appellant. And in my submission, that tends to go with the procedural fairness point generally. That although that's in the context of a hearing, but even in the context of a decision making generally where there's no right of appeal, that principle applies. And I'm coming to the end of my submissions very briefly. The decision in ACTURC, which the relevant paragraph, was on page 117 of the authorities bundle. Paragraph 42.
117.
Yes.
I mean, this is Mr. Justice Holman as referred to in one of the previous authorities that we've looked at.
In Carrigal, yes, it was referred in Carrigal, yes.
Would we get missing
Um,
more authorities in this field on their own facts?
Just that penultimate sentence, my lord, where the court observed that in that paragraph, save where there is powerful documentary evidence of a lack of genuineness, it is a strong thing and likely to be unfair for any decision maker to reach an adverse conclusion as to integrity, credibility, or legitimacy without at some point in the process the person having an opportunity. And so it's really the point of integrity, my lord. But, and then 43 deals with the resource implication point of having to follow the process. My lord, the part of the decision in Citizen UK was referred to in Carrigal, and I've said that out of paragraph 27 of my skeleton.
Thank you.
Thank you. And very finally, my lords and my lady, the respondent could have stated that the applicant's circumstances were optimistic or unrealistic, or that she was naive in not declaring her previous refusal. But the respondent went much further than that, and she attacked her integrity, credibility, and doubted her intentions.
Well,
Yes,
given
that's
that,
the solution. Yes.
given that the guidance actually requires that to be the test.
Yes. The rules, my lady, I think requires this.
Yeah,
Yes.
sorry, the
Sure.
rules require that.
Yes, but I think we've established that
Yes, we have.
say that a refusal entails, in all normal circumstances,
Well, the
as it were,
language.
a finding that
Sure.
gives rise to a right.
Yes.
Yeah.
Yes, my lord. Although my lords and my lady, the language of the rules is perhaps unusual in that genuineness is it's a difficult concept to judge.
Is just help me. Is the sort of application that was being made to the minister in this case, is it pretty much at the bottom end of all possible applications? I mean, I appreciate it's very important to keep in touch with one's
of course,
family,
yes, yeah, sure.
and there are all sorts of issues that one could easily see. But I mean, obviously, we deal with cases also that concern the deprivation of citizenship and
Absolutely.
and
yes.
deportation and so forth. I mean, I just wanted to situate myself
Yes.
within the immigration context. Are these, in a sense, the most commonplace, regular, routine applications?
Absolutely, my lord. So these applications, my lord, are applications which generally do not involve human rights considerations.
Not involve human rights.
Considerations, yes.
Yeah.
You could, my lord, have an Article 8 claim in a visit visa refusal, depending on the facts. For example, if you had a bereavement in the family in the UK and you wanted to come. But generally, they do not. I mean, in this case, the lady wanted to come and see her son who resides in the UK. And I think there was some previous intention to live together, which is a reason provided. So for her, it was important, my lord, and of course for her family members or member who's here. But I accept, my lord, that this is not an application for leave to remain.
Yes, I understand, but I appreciate also that it'll be a very frequently made application.
Yes,
so
yes, certainly. Yes.
But that's important in the system as a whole.
I will just very finally, there's one last case with my Lord's permission. Paragraph 29 of my skeleton is a case of a registered car, Tamina. Is a decision of this court, page 208 of the authorities bundle. Paragraph 54. And this is the second sentence in that paragraph. If an allegation of conscious wrongdoing is being made, it should be made explicitly, and the applicant should be given a fair opportunity to deal with it. And respectively, my submission is, my lords and my lady, that the reasoning provided by the respondent demonstrate, or at least implies, that the appellant did wrong by knowingly failing to declare the previous refusal.
Yeah, you've got to be careful about this though, because this was the Upper Tribunal judge who had, for the first time, made a finding that somebody was complicit in a running of a business where their job did not match the description, and the Upper Tribunal has done it without any evidence at all, without even having raised it during the hearing.
Yes, I'm grateful.
First time the applicant knew the finding of complicity was when they discovered it in the judgment.
I'm grateful. I'm grateful. Yes.
It was a pretty extreme case to me.
I'm grateful, my lord. Thank you.
I mean, and in fact, the judgment was perfectly good on the other two grounds,
Yes.
as the rest of the decision said. But it's just an application of what you could say is that, as with all of these, I think we went back to duty. I think, didn't we?
Yes.
And like you always just go back to saying that procedural fairness is fact sensitive and context sensitive.
Precisely. My lords, my lady, the decision of Judge Kopicek in this case, at page 24, does not appear to deal with the procedural fairness point at all in any explicit fashion.
Well, I don't think, in defence of the judge, it was quite articulated before him in the way that you're articulating it before us.
That's right.
It was buried away as part of ground one, where there was a general complaint that it wasn't open to the Secretary of State to come up with reasons that weren't in the earlier two decisions.
My lady, may I take you to the renewal grounds or before the judge in the Upper Tribunal? First of all, my lady, the skeleton argument I'll take you to, which was before the judge, and that's.
Skeleton argument is not your grounds.
Oh yes, I'm so sorry, my lady. Yes, it's my lady, page 32 of the bundle, where the renewal grounds are.
It's 4, is it?
It is 4 to 5. Yes, absolutely, my lady. Thank you. My lady, this court is concerned with whether or not the decision of the Upper Tribunal was right in refusing permission to apply for judicial review. So the threshold, the bar is relatively low. As lady, there was a recent authority handed down on the 25th of March, a copy which was provided to the court from the Privy Council. And it's paragraph 83 on page 26, if I can take respectfully the court too. And it refers to the role of this court in a challenge like this, and the paragraph 4 referred to from the case of Sharma. Says that the ordinary rule now is that the court will refuse leave to claim judicial review unless satisfied there is an arguable ground for judicial review having a realistic prospect of success. and on page 27, at the end of paragraph 83, which carries on to that page, it says, as Lord Sale said, this is a low threshold, referring to the test. It operates to filter, as a filter to exclude cases which are unarguable. And then paragraph 84,
Well, the test is set out in the middle of paragraph 84.
yes, yes.
Has the judge erred in concluding there's no arguable ground for judicial review?
Yes.
That's the test we have to apply.
Yes, yes, I've seen that, yes. And my lady, at paragraph 89, there's observations about judicial review, in particular, and why it's different to order of disputes, which of course is well familiar. But the last paragraph in this case.
Sorry, is it that there's no ground for judicial review, or is it there's no realistic basis for relief being granted? So I'm just trying to get back to where we started from in many ways.
Yes.
Is the question, is there a reasonable ground for saying that there was procedural unfairness, or is it the basis for saying that, is there a reasonable ground for saying that
As I understand it, my
court would grant a remedy on judicial review?
as I understand it, my lord, the test is whether it is arguable that the looking at the decision of the Upper Tribunal to say whether it erred in not finding that it is arguable that the decision of Secretary of State.
Yeah, but when you say arguable ground for judicial review, that's shorthand.
For permission to apply for judicial review.
Yes, but on judicial review, as I understand it, there are two questions. The first is the decision vitiated by some sort of unreasonableness, unfairness, or any of the other grounds upon which the court would judicially review a decision? And then the second question is, if so, what does the court do about it? Is there a remedy to be granted?
Yeah.
Now,
Yeah. Yes.
we started off by saying
Yes. Yes.
the mere fact that, for example, if there were 4 grounds, that one of them might have been vitiated by procedural unfairness wouldn't help you if the 3 other grounds stood independently and would be support for the
Yeah.
decision. So the question wouldn't, for the court, as I understand it, wouldn't be just as a matter of theory, is that an arguable ground on which you could attack part of the decision? It would be, is it reasonably arguable that you'll get an outcome out of the judicial process? I'm trying to use words that are very clumsily.
I think my lord is referring to the whether the outcome whether it's highly likely the outcome will be different.
31(2)(a).
Yes, but my lord, it may assist to look at this case, the paragraph 92 of this case, which page 30.
Sorry, 30 of.
Sorry, no, page 30 of the recent authority that I handed this
Okay,
morning.
okay.
Recount
Yeah,
it.
sorry, I'm back.
Paragraph 92. Yes.
Yeah.
Thank you. And again, my lord, my lady, that refers to the arguability test, essentially.
Yes, but it goes on. If you look at paragraph 93, it doesn't confine it to the arguability test, because the court can take account of a lack of candour. Nobody's suggesting a lack of candour in this case, but that suggests that the court is also stepping into the shoes of the decision maker to see whether, as a matter of discretion, judicial review should be refused or permission should be refused.
Yes, I see that. Yes.
I think possibly the way you might put it, Mr. Fasley, very fairly, would be to say, well, if you come to the conclusion that this is an arguable point and that permission would normally be granted for an arguable point, it's not for this court to usurp the view of the decision taker as to whether or not he would refuse permission to proceed on some other ground. And a fortiori, you wouldn't preempt the decision of a full court, a court or tribunal dealing with this in the round, as to whether at the end of the day they'd say, well, there may have been procedural unfairness, but it doesn't matter, and therefore we go down 31.
Precisely, Mary, that's the decision in the case of R in the application Harvey against Mendip District Council of Lord Justice Sales, paragraph 47, where he said, a court will be appropriately careful in reviewing evidence produced by a decision maker long after the decision to say how they would have proceeded, and will evaluate it carefully in light of the contemporaneous materials in this case, and that it is nonetheless telling that none of the decision maker in this case have failed to put before the court any witness statement to support the contention. My lady, the yeah, the no substantial difference test, as it was known then, my lady, the test really is all the appellant needs to establish is that but for the procedural unfairness, the outcome might have been different. He does not need to show, she does not need to show that the outcome would have been different, as the authority in Hadrian Woodhouse. Those are my submissions, my lady. My lord's disagreement further assistance.
Just one moment. Could we just look once at the order granting permission to appeal again, which is at 164. So that's what we're here to consider, which is whether the refusal could be challenged on the basis that you were not put on notice in relation to the earlier application, not given an opportunity to comment. If we go back to the Upper Tribunal's decision, at 24, paragraph 1, the judge said that third line, the respondent didn't represent and the applicant had no reason to suppose that additional reasons for refusal had not previously been raised. And lying behind that conclusion was your renewal application, where you've taken us to paragraph 4, which was the valid point.
Yes.
Right, so just putting this in context, it seems as if the Upper Tribunal judge did not deal specifically with that point.
Yes,
beyond what I've just read out.
Yes,
and that permission to appeal has been granted in a way which you would say is broad enough to allow us to consider it.
Yes, my lord.
But having got to this point and following up your reminder that we are here considering, as was the case in Wahid, a refusal of permission, and you referred us to the low threshold guidance about this. What are you saying? That we don't have to decide whether there was or wasn't a duty? We have to send that back for somebody else to wrestle with? I mean, I'm just working out what we're doing here.
Okay, great.
Because it seems counterintuitive that having heard full argument, as we will have done on this very point, that we shouldn't decide it. And having decided it, that would, in a sense, deal with the judicial review, because either we wouldn't give permission by refusing the appeal, or if we thought we should allow the appeal, then we would effectively be deciding it in favour of there having to be a reconsideration, unless we were considered under 31 2A that wasn't
Yes.
appropriate.
I'm
So
grateful.
I just want to understand whether you're saying that we're really limited to saying, well, that seems like a good argument, but we'll let somebody else decide it.
Yes.
I mean, surely we have to, having got to this point, it's not a sensible use of resources for us to shuffle that off onto somebody else.
Quite right, I agree entirely, my lord. Given the narrow issue in this case on that point.
Right, so we better make up our minds as to what the duty was in this
Yes,
case,
absolutely.
even though we're in a context of a refusal of permission rather than a refusal of judicial review.
It's entirely, yes, my lord. I mean, that would be fair option. We're so open to you, my lord.
So I was wondering how cautious you wanted us to be, but not very in relation to that matter. You want a finding in your favour on that legal issue.
Yes, my lord, yes.
Well, that's helpful to me at least. Anything else? No.
There's just one point, my lord, for accuracy of record, you referred to the instructing men solicitors. He's actually a direct access barrister with a chamber of his own.
Ah.
Yes, so instructed by a barrister's chambers who has a litigation extension.
Right.
Yeah, just great. I'm grateful.
Good.
Thank you.
That's been extremely helpful, Mr. Fazley, and thank you both very much.
Thank you, my lord. I'm grateful.
Yes, Miss Masood.
Thank you. Might it be helpful if I begin by dealing with the last point, which is what this court's role should be?
Yes, and it will certainly
it's
going to be
that right,
it's going to be
doesn't it?
helpful to me if you can keep your voice up, please.
Very well. I'm sorry if I haven't been loud enough. I'll
No.
try my very best. Our position is that the court should take a conservative approach. In other words, simply decide whether or not permission should have been granted. And if this court decides that the permission to apply for judicial review ought to be granted, then it should be remitted to the Upper Tribunal for the claim to proceed in the usual way. And the reasons for that are as follows. The first is that the Secretary of State hasn't fully pleaded a response to the challenge, because if permission is, in the usual way, if permission is granted, she would have a chance to provide detailed grounds of defence, she would have a chance to provide evidence, and in this sort of case she may well wish to provide evidence on the issue of procedural fairness and, for example, the practicality of, say, a minded to process in entry clearance cases, for example. There are issues that she might want to cover in evidence which she hasn't had a chance to do because we are still effectively at the permission stage. And the second reason is that although very understandably this court has taken a pragmatic approach and admitted my learned friend's skeleton argument, it does raise, I say, new points or new ways of putting the point, which my client hasn't had a proper chance to properly consider. I'm prepared to deal with
When you
them.
say when was it received?
It was received on or about the 7th. I think it was the 10th of February that certainly my instructing solicitor sent it on to me. But as I say, it wasn't opened until very recently
That's the
because we thought it was a
problem, isn't It's
replacement
not that she
skeleton.
didn't have a proper chance to look at it. It's just that it wasn't open for reasons you've explained.
Yeah.
Nobody's criticising.
Yeah. Although I'm not suggesting I'm not in a position to deal with the arguments today on the basis that this is a permission hearing, I'd be very wary to say, well, I have all the instructions I need, and I've got all the arguments that I need to deal with the point substantively. And so for those reasons, I would ask this court to take a conservative approach. I understand, of course, my lord, your concerns. There are resource implications, of course. We've been arguing now for half a day and it's likely to go over lunch. But for the reasons I've outlined, my instructing client, the Secretary of State, ought to have a proper chance to deal with what is potentially an important point, particularly if it's likely to be decided against her, of course.
Can I just ask you about, you said that you want to put in evidence?
Well, we might want to put in.
Well, you might. I mean,
Yeah.
can I just test that for a second? I mean, if the proposition is that procedural fairness requires somebody to be given an opportunity, in the broad sense, just to address what the decision maker is likely to base their decision on, making a finding of dishonesty or something akin to it, impropriety if the court just simply says they have to be given an opportunity, it's up to the Secretary of State to find a way of implementing that, isn't it? I mean, you can't say, well, actually, it's just too expensive to give people an opportunity if that's what procedural fairness requires.
I'm certainly not running the argument before you today. First, I'd like to make that clear. And the second is that the point is we simply haven't had a chance to think about those points because this is still at the permission stage. I mean, those are the sorts of points. I mean, that's just one example I've given. There might be other things that we want. There might be other points in which we want to put in evidence. It wasn't clear to me until the very end that the appellant would be endorsing or would be inviting the court to essentially decide the point substantively. I mean, so I haven't had a chance to take instructions beyond just turning my back. But there may well be things. There may well be. Sorry.
I mean, when Lord Justice Newey gave permission, it was on the grounds that it was a failure to give an opportunity to comment. I mean, the concept of what an opportunity might involve has been around since April last year.
Yes, no, we've always understood what the point is, but at the permission stage, the respondent doesn't typically provide evidence. The pleading is more limited. There might be arguments that we wish to run at the substantive stage, which we haven't run at this stage.
But this is it's an interesting point you're making, but this is a point of law. It's not. It's going to be the same last April as it is next April, or if we send it back to be decided in the Upper Tribunal, the April after that. It's simply a point of law, isn't it?
It is absolutely a point of law, but as Doody establishes and cases such as Balajagari and others accept, what procedural fairness requires is all dependent on the facts and context. So yes, it's
which facts and context of this case don't we know? We know all the facts of this case. How your client might have to implement the opportunity in other cases is that relevant to the question of what procedural fairness requires in this case?
It's simply one example I gave. It may well be a bad example, but there are arguments that we've come prepared today to deal with a permission hearing essentially, based on limited pleadings that you have at a permission stage. Now, the applicant's grounds were very limited. They've been developed by my learned friend in the course of his oral submissions today and in the skeleton argument that was served on or around the 7th of February. The parties are only, in my respectful submission, really prepared to deal with the point of permission stage. I certainly haven't come prepared, and I don't have. I mean, I can take further instructions over lunch.
You accept that if we came to the conclusion that it's arguable, we've got to go through this all over again, or rather, you've got to go through this all over again.
We have to grant permission.
Yes, we'd have to grant
for judicial review.
Yeah.
Yes.
And then it would have to be argued out in full in front of the Upper Tribunal.
The same point of law that permission was granted for last April.
Yes.
And then
what is it with the extra time that's going to change?
It's not an issue about time. It's not that we need extra time. It's that
Well, what do you need more of?
Well, the parties
and what is it that you would do if you had more time?
This has never been proceeded on the basis that it's a rolled up hearing. The pleadings before the court are the more limited pleading one normally has at permission stage. As I say, there may well be that those instructing me decide they don't want to put in evidence. I just haven't had a chance to have that conversation. Now I can try and have that conversation over lunch if it would assist, but the point is we just haven't had that opportunity because this is a permission stage case. Essentially, is the point.
So it should be sent. It should be sent back to the Upper Tribunal with permission granted. If we don't refuse the appeal, with permission granted, in order for the legal arguments to be made, because we're not concerned with the rights and wrongs of the decision. We're simply concerned with what the rules of engagement are.
Yes.
In relation to what the fairness requirement is. And so that ought to be argued out at Upper Tribunal level.
Yes, and that was the approach that was taken in Wahid. This court did remit the matter to the tribunal for it to be fully argued out. In the event it was settled, those are my instructions. But we invite this court to take the same approach. Ultimately, it's a matter for this court, of course, but I'm simply setting out what our position is, which differs from the appellant's position.
Well, there's the interesting and more difficult wrinkle is that Parliament has not yet seen fit to allow this court to, as I understand it, if a judicial review comes up from another court, then this court can take on the substantive, instead of granting permission, can simply deal with the meat of the judicial review. But there's no statutory power to do that.
It generally constitutes itself as a divisional court.
Yes.
Yeah,
It's
that's my
historically
understanding.
been done.
Yeah.
Yes.
So I'm certainly not suggesting that this court wouldn't have the power to do it. My submission is simply that it wouldn't be appropriate for the reasons I've given. If we'd had advance notice that this was the position, and I appreciate this is no criticism of my learned friend because he took the position he did in response to a question from the court. If we'd had advance notice that this is the position that the appellant was going to take, then we might have been able to prepare on the basis that this was a full judicial review, but we haven't prepared on that basis. That's simply the point I'm making. I don't think I can improve the points I've made. As I say, the only instructions I've taken are just what I've been able to do while speaking to my instructing solicitor behind me. If it would be helpful, I can take instructions over lunch. But as things stand, those are my instructions.
Yes. All right. Well, I think we might just think about this for a moment. I'll do sit down for a second.
Very well.
We might take lunch at this stage. Should we take lunch at this stage? I think that this is sort of structurally significant for the task that we're engaged on, and if I've precipitated it, then I'm both sorry and pleased that at least it didn't lie floating in the water for us to encounter at some later stage in the day. Would it be inconvenient if we were to take an early break at this stage? I'm not doing so just so that you, Ms. Masood, can take any further instructions you think appropriate. It's not one of those situations where we're saying we're going to have a long lunch so that you can go in, as it were, come back and say something different. Far from it. Just to give you an opportunity to reflect on this in an entirely open manner, and if it remains your position, then you'll tell us when we return. Which would it be inconvenient if we return at 1:45, so that time isn't lost? Is that inconvenient? It's all right. All right, but as I say, it's an opportunity for you to have further thought about this, but it's not. It doesn't come with any spin to it. If that remains your position, that will be your position, and we'll then think about how we should proceed. All right.
Would it be helpful if I just handed up the?
Was this part of the?
Rules? Yes.
Yes.
So that you have it.
Let's take those with us. Just give us a description of what these are.
Part 9, relevant sections of Part 9 of the immigration rules, the general grounds of refusal.
Immigration rules.
Part 9.
Yes, you said something else.
General grounds of
General
refusal.
grounds of refusal.
And how wide are those? They involve all kinds of
Yes.
kinds of application, including the one in the present case.
Yes, it applies to applications, visit visa applications. It doesn't apply to all applications, but it does apply to visit visa applications.
Right. However, this was this was not the basis upon which permission was a visa was refused in this case.
Yes, but that's precisely the point I wanted to make, that this wasn't the basis. On
Right.
on
So there is, as it were, a nuclear option
Yes.
for refusing permission
Yes,
under this part, but that wasn't
that
employed.
wasn't done. Yes, that's precisely the point.
Okay. 145.